Yes, Mr. Member.
May I please your lordships, my lady. With the board's indulgence, can I come back again to this issue or the issue of the threshold of cogency?
Yes, please.
And perhaps I can do that by way of illustration by reference to the case of Wallace, which is at page 3905 in the bundle of authorities at volume 3.
Just give us the tab number as well, please.
The tab.
It's tab 39.
39.
Now, this was a case from a conviction for murder where the appellant sought to challenge the evidence given at trial, identifying his fingerprint on a diary belonging to the deceased. The evidence was unchallenged by his counsel at trial, who had first obtained an independent expert opinion that confirmed the Crown's expert identification. Now, at paragraph 76 of the judgment, which is set out in the respondent's submissions at paragraph 52, the New Zealand Court of Appeal stated this: given the context, this fresh evidence cannot be sufficiently cogent to allow its admission post-trial, let alone be a basis for or contribute to a new trial. This court cannot allow post-trial shopping for another expert to challenge directly relevant expert evidence which was admitted at trial and cross-examined on. Again, we repeat the caution voiced earlier in the judgment that with respect to scientific evidence, a court should never say never. It is conceivable that there may be subsequently be powerful scientific evidence which renders a point advanced at trial simply incorrect. But in this instance, Mr. Acra's evidence is nowhere near sufficiently cogent. It is simply a different view on how many possible points of identification are required to be able to give a professional opinion. And that reflects a similar approach in my submission in England. And I refer the board to the case of Queen Anne Jones, which can be found in volume 2 at tab 26. And the quote from that judgment is set out at paragraph 53 of the respondent's submissions. The court observed that the statutory requirements of freshness and credibility were more applicable to new factual as opposed to expert opinion. And this is at page 3450 of the bundle. Commencing just after line C on that page. The giving of a reasonable explanation for failure to adduce the evidence before the jury again applies more aptly to factual evidence of which a party was unaware or could not adduce than to expert evidence, since if one expert is unavailable to testify at a trial, a party would ordinarily be expected to call another, unless circumstances prevented this. Expert witnesses, although inevitably varying in standing and experience, are interchangeable in a way in which factual witnesses are not. It would clearly subvert the trial process if a defendant convicted at trial were to be generally free to mount on appeal an expert case which, if sound, could and should have been advanced before the jury.
We don't have an equivalent of Section 23 of the Criminal Appeal Act, do we?
Not
So
in
how do you tie this into our legislation? Is it simply the approach you say should be adopted to Section 385, or...?
In my submission, it reflects the appropriate approach to the admission of expert evidence on appeal. And Section 23 of the English Act, in my submission, reflects the orthodox approach to the admission of expert evidence. The case of Chatou, which again is referred to at paragraph 54 of the respondent's submissions, attempts to distill the principles contained in Section 23, and it must be remembered that perhaps it's worthwhile going to that.
Just before you leave Jones, is it worth just seeing what happened?
In Jones? Yes, well, Jones was a case...
Jones was a case in which Professor Knight couldn't be called because he wasn't available.
That's right.
There wasn't any application made to call somebody else to say the same. And the Court of Appeal in due course decided, on balance, that it should nevertheless receive the evidence of Professor Knight, though having done so, it did not allow the appeal.
Indeed.
So it's, whilst the general principles which Lord Bingham set out and which are oft cited are important, it's quite interesting to see what happened.
Indeed, there the court heard the evidence, but concluded that they had no difficulty, or they had no difficulty in concluding that the conviction was safe.
Yes.
Well, was it by recourse to the interest of justice rubric that they had the evidence?
Yes.
In Jones, yeah.
Yes.
So the case of Chatou is at tab 14, volume 1 of the authorities. And at paragraph 70, the Court of Appeal seeks to distill the principles that can be
Sorry,
derived.
where is... Oh, 14, sorry.
Tab 14,
Yeah.
tab 14, page 3151.
Thank you.
It's perhaps worth noting, my lady, in respect of the issue that you raised, Section 23 is set out at page 3150, and it refers to the admission of evidence.
They're fairly obvious points in
Indeed.
subsection 2, aren't they? I mean, the
They are.
overriding test in 1 is, as you've been submitting before lunch, I think.
And they inform the overarching test of necessary expedient in the interests
Yeah.
of justice. So the point that I seek to make in reference to that case in particular is the fourth point made by the Court of Appeal in paragraph 70, which states, save in exceptional circumstances, the Court of Appeal will not permit an appellant to mount on appeal an expert case which, if sound, could and should have been advanced before the jury. To do so would subvert the trial process.
Well, I'm just wondering why, looking at 23, 2D, there has to be a reasonable explanation for the failure to adduce the evidence at the trial. But if there is a reasonable explanation, I mean, if there isn't, you don't get off the ground, but if there is a reasonable explanation, I'm not sure why the court should be so hostile to receiving expert evidence.
My Lord, I suppose that begs the question, or the evaluation of the reasonable explanation.
Yeah.
It's introduced that subparagraph by the words "save in exceptional circumstances," but that doesn't seem to appear in section 23. It's reading more into section 23 than it states.
One can see at a theoretical level that there's an obvious potential, at least, for tension between two competing concepts. On the one hand, the one trial process and the utter undesirability of allowing a defendant to relitigate a criminal trial, especially because the potential deficiencies in the scientific evidence are exposed and can be analysed post-trial, and there's at least the possibility of generating evidence that will seek to exploit such deficiencies as obtained. That's one side of the argument. The other side is, if evidence is brought before an appellate court which demonstrates that there may have been a miscarriage of justice, then arguably the one trial process has to yield to the greater good that a miscarriage of justice where an innocent person has been convicted is the more powerful concept. Would you accept that?
If the appeal court ultimately comes to that conclusion.
Yes, but it may do in the face of having to accept that it involves a process, to some extent at least, of relitigation of the defendant's advisors isolating, identifying the difficulties that the scientific evidence threw up, and obtaining evidence to seek to exploit those. But if, in the final analysis, taking due account of the one trial process principle, the court is left with the conclusion that there is a real risk that a wrongful conviction has been rendered here, then the mere fact that it encroaches on the one trial principle cannot alone prevent the court from having recourse to its power in the interest of justice to receive the evidence. Do you accept that?
I accept it as the Lord has articulated it. However, I think two things need to be borne in mind. Firstly, there's been a proper trial. The person has been properly convicted on the evidence that's been adduced at trial. There is no trial error. If the evidence that is put before the appeal court is nothing more than a relitigation or an augmentation of the evidence that was put forward at trial, that, in my submission, doesn't raise an issue of justice sufficient to overturn the conviction.
Well, it depends. It depends on the nature of the evidence. I mean, it can't be deprived of that condition simply because it involves relitigation. I mean, there has to be an examination of the intrinsic merits of the evidence that's proffered, surely.
There does, but there also has to be, in my submission, an acknowledgement of the finality of the jury's verdict. And the jury ultimately is the determinant, determines guilt or innocence. It's not for the appeal court, and one can't take the trial as some type of curtain raiser to a...
No, quite. Well, I mean, I think I was careful to say that you have to have regard to the one trial principle. I'm just trying to struggle with how, in the more difficult cases, and this may be an example of it, where the adducing of the proposed evidence may partake of relitigation, but nevertheless may demonstrate that there is a real risk of a miscarriage of justice. How does an appellate court reconcile, or how does it resolve the tension between those two competing theories?
Well, in my submission, firstly, it would require an extremely analytical and forensic process. So the evidence, the fresh evidence that is put up, would need to be examined in great detail as to what actually it amounts to. And the purpose for that observation is that in my submission, an appeal could not be allowed on fresh evidence simply on the papers, unless it was demonstrable on the papers. And I will refer the board to an observation in that regard by, I believe, Lord Justice Bingham.
I wonder, though, whether it wouldn't be helpful to get into the detail. I mean, we've spent quite a lot of time now exploring this very interesting point, but and no doubt you'll come back to it once you've put flesh on the bones and we've really got a feel for the way you're asking us to approach the points that have been raised against you. I think partly to make progress in view of limited time, but also I think the stage has been reached when we really want to look at your what the detail is in this case as you invite us to look at it. And it may be the point is clarified by that presentation.
Yes. Please, Your Lordship. If I can turn then directly to the first ground appeal.
Yes.
In the respondent's written case, that commences at paragraph 80. And the written case reviews the evidence that was called at trial, and I won't take the board through that. However, it is perhaps worth noting at paragraph 89 Mr. Sutherland, the forensic scientist's examination of the polo shirt. He took some adhesive tape lifts to preserve trace evidence and gave the reference number. And under a bright light, he then noted and sampled the two smears, which are, of course, at issue. First of all, he identified a visible whitish-brown smear, approximately 30 millimetres by 20 millimetres on the front left sleeve of the shirt, and chemical tests indicated the probable presence of blood. A dab slide was taken from the stain by rubbing a moistened slide against it, and this slide was given the reference number as it's recorded. The stain itself was cut out and given a separate reference number. It is worth noting at this point that the dab slide, as it is indeed described in evidence, involves the moistening of a slide and it being rubbed across the stain. So all that comes into contact with the stain is the and comes into contact with the slide is the surface of the stain. The second visible white smear was approximately 25 millimetres by 10 millimetres on the chest pocket. Traces of blood were visible in this stain when it was examined under a low power microscope. And that stain was also cut out and given a reference number. The DNA testing, the two stains that were cut from the shirt were forwarded to the ESR for DNA testing. That's the New Zealand Forensic Science Service. The results of that testing were not disputed at trial, and there is no allegation, as I understand it, of any incompetence on the part of Mr. Behrens, or error on the part of Mr. Behrens in making that concession. And as we know, Mrs. Lundy was the source of the DNA. As it was described by Mr. Sutherland at evidence, the source of the DNA found in the biological material in both stains. And that's the description he gave in evidence. The scientist who actually undertook the DNA...
Was he cross-examined on that expression at all?
Not that I can recall, my lady.
I think Mr. Hislop suggested that it was either within or proximate to the material that had been identified as brain or spinal matter, but it wasn't possible on the evidence to say with complete certainty that it was within that material.
Well, I can't take it any further than the evidence that was given at trial, which is the description that was given, except to acknowledge perhaps what is a matter of general knowledge, and that samples are washed, and that is what is studied.
Yeah. So I may be misremembering, but I think Miss Vintner may have explained that to the jury, that what she was examining for the DNA was actually a washing taken from the sample that had been given to her.
I'm obliged.
Mm-hmm. So the two findings on the shirt, which are at 89, 1 and 2, one on the left sleeve and the other on the chest pocket, are both DNA of Mrs. Lundy. Is that right?
That's correct.
And those are both the ones in which Mr. Miller asserted could be detected brain cells.
That's correct, my lord.
And plus we've got amber somewhere, haven't we?
There were trace
Yes.
in the tape lifting process, a number of blood particles were picked up. At paragraph 300 of the respondent's case, that evidence is summarised.
So it doesn't come in this particular bit, does it? Because we're dealing with brain tissue in this chapter.
It doesn't, but that may be a useful... paragraphs 300, 302 is perhaps a useful summary of what that evidence amounted to.
And where was that on the shirt? Do you happen to know?
No, it was not identified.
No.
I think all he said was that there were lifts from the front of the shirt. I think. Thank you. What he said.
Just in relation to the DNA in the photographs, it's page 136 of the photographs.
106.
136.
136.
Oh, I see.
In the bottom photograph, one can, well, in the first and the third photograph, one can see where the small samples were taken from, on the sleeve
So,
and on the chest.
yes. And what was the number given to Amber's one? Was it
303 stroke 1.
The 3031?
Which,
Yes, C303 bar 1A.
Yes, we don't have a photograph of that, do we?
No.
No.
I don't think, just my recollection of reading the evidence, he couldn't be specific as to where these spots, these flecks had been. He'd simply done lifts with sellotape or something of the kind on the front of the shirt, and when he looked at them, he'd picked up some pieces of what looked like red dust.
Yes.
So, originally I thought it was a sort of concentrated spattering, but it doesn't seem to be that at all. I mean, you know, sometimes when blood is spurting out, you get a scatter of them in a particular location. But the picture we're now being given is of just random taping over the front of her garment.
That is my understanding.
Yes.
Is there evidence as to why that was chosen? Was that on the basis of a simple visual examination that they chose to take the sample from there?
Sorry, the samples of the stains?
Yes,
Yes, they were visually seen
I see.
under a bright light, a specialist forensic light. They were visually actually seen as a visible whitish brown smear and a visible white smear.
With the bright light, was it applied to the entire garment?
My understanding is that the entire garment was inspected in that way.
And so the only two areas which yielded DNA results were these two, so far as Mrs. Lundy was concerned.
That's correct.
we don't know whether any other part of the shirt was tested for DNA, do we?
Well, I'm sorry. The only stains, the only
stain.
visual material that was seen, that is correct. And the taping that was, all that was picked up in terms of trace elements was this blood.
Yes, but the interesting feature, if I've understood this correctly, is that we were told in paragraph 89 that Mrs. Sutherland took these tape lifts, and the findings from the tape lifts are what we see at page 300, and they're amber. They're not Mrs. Not Mrs. Lundy, as I understand it.
That's
So the link with Mrs. Lundy are these two particular smears, which are identified on the front of the polo shirt.
That's correct, my lord.
Yes, first tape lifts, hence amber. Secondly, bright light, and these two little patches.
Yes.
Yeah.
Yep.
Yeah, I see, just confirming what I said a moment ago, it's at page 806 that Sutherland explains that he tape lifted from the front and back of the shirt using sellotape, and then on 810 he says that he found red particles and that they had come from the tape lifts from the front of the shirt, and he's asked if he can remember specifically where, and he couldn't. So the tape lifting process just picks up trace evidence as you move the sellotape over the surface.
Yeah.
Now, as has been alluded to, the ESR slide, that's the DAB slide, C3003 bar 2, was examined by a number of pathologists under microscope.
You may be right that was 303.3.2, but it's not what you say at 90.
Sorry, sir. C3003 bar 3 and 4 are the two stains, the material cut from the shirt. The ESR slide, which was produced from the stain on the sleeve, was given the reference number C3003 bar 2.
That's 93, paragraph 93.
And it was that slide that was initially examined by local pathologists to see whether or not they could conclusively identify the cells as being from the brain, or at least via central nervous system tissue.
So there was just one slide, and it was from the sleeve.
That's correct. At that point, just the one dab slide taken by Mr. Sutherland. And the local pathologists, while expressing views, could not be conclusive as to the character of the tissue on the ESR slide. And it was because of that lack of ability to be definitive as to what the cellular material was that caused the search for expertise which may be able to provide a conclusive opinion as to the nature of the cellular material. And initially, as set out at paragraph 95 of the Crown's case, initially Dr. Miller's name came up because he was known, having attended a conference in New Zealand and through some other associations with the local pathologists, he was known to have the ability, or to have pioneered a means by which material on a slide could be transferred to another slide.
Oh, yes, yes,
As a special technique.
yes.
And because that was all that anyone at this stage understood was available for further analysis. As it turned out, when Dr. Miller became involved and when the stain samples that had been cut, the material samples, C303 bar 3 and 4, were made available to him in the United States, he came to the conclusion that in fact it would be worthwhile examining those samples and subjecting them to the normal IHC process to see whether or not, by that process, a positive identification or conclusive identification could be achieved using IHC techniques. And that is ultimately what he undertook.
Yeah.
And at paragraphs 98 through to 103, the respondent summarises briefly what Dr. Miller did. The two strips of the shirt fabric comprising the areas of staining and two control strips were processed in the ordinary way, resulting in the fabric being embedded in small blocks of paraffin wax which could be thinly sliced to ultimately produce slides which can be examined under a microscope. And what is important to note in my submission at this point is that what he obtained as a specimen for examination through slicing the paraffin wax, the block, was a different sample than the dab slide which had been obtained by the ESR, which was a surface, an application of the damp slide onto the surface of the stain, as opposed to what Dr. Miller did, which was in fact to take strips of the shirt, immerse it in paraffin wax in the normal IHC process, and then cut it, which allowed for a cross-section, and indeed, in fact, a three-dimensional image of the cellular material. Quite different from the ESR slide, which, as I have said previously, was obtained from the top of the stain.
But are you going to say, I mean, is it the same material, or are you going to say that the surface of the material might have been different from what was beneath the surface?
Well, clearly, Mr. Sutherland applied the dab slide to the visible stain, and equally clearly, Dr. Miller, as he describes, took his samples from the embedded fabric, which included the visible stain.
So the embedded fabric went into the paraffin wax as well, did it?
Strips of the stain.
Well, when were the strips made?
In the United States.
I know, but was it after it had gone into the wax or before?
No, before is my...
So what's the process involved there? I mean, we've got Mr. Sutherland swiping his moistened slide across the stain, and then you've got the remnants of the stain remaining on the fabric. Now, was there a slicing process undertaken before it went into the paraffin wax?
My understanding is that the fabric itself was... the slicing certainly took place of the paraffin block.
Yes.
Perhaps if I can go to the evidence to be
Yes, that'd be very
Mr.
clear.
Miller explained it, didn't he, to the jury?
There's an affidavit which explains it, and we've got the evidence as well.
Perhaps the affidavit may be the...
Where's his evidence?
I'm not sure where it's going with it.
It's at tab 17 in volume 5. Commences at paragraph 20.
Sorry, I missed that.
So it's volume 5,
Yes.
tab 17, paragraph 30, did you say? 30? 20. Yes.
So it refers in paragraph 20 of placing two strips of the shirt, and I'm sure that in fact there are photographs that show that is a cutting from the sample itself, which is then put into a small plastic container for the purposes of the process.
There's quite a helpful sort of PowerPoint demonstration at 2254 onwards.
Yes, I'm obliged, my lord.
Yeah, so the cover is put on top, is that right? And then
Where are you?
you're to be filtrated.
2254. Thank you very much.
I'm not sure there are a great deal turns in this, but it's obviously necessary to understand as best one can the procedure, just in case there is some significance to it. But my very quick reading of that would suggest that the slicing or the cutting took place after it went into the paraffin block.
Yeah, I think
Well,
that's right.
there's both cutting and slicing, isn't there? You start with a little tiny section of shirt, smaller than that, but a little rectangle of shirt. You take part of it, thus preserving the rest for being able to use it again. You fix that in your paraffin block, and then you slice it incredibly thinly. And the fixing in the paraffin block and the slicing incredibly thinly, unless I've misunderstood it, is standard slide preparation technique, isn't it?
That is,
It's not. I mean, all scientists do that.
And then you end up with a section which we can see at 258, which you can then examine microscopically. So
that's right.
it's really a kind of tissue which you're left with, presumably a very thin piece of tissue.
Very thin, you can see through it.
Microns, I think.
And the block is available, it's still available, and slices are still being taken off it. After Dr. Miller had subjected the samples to that process and had obtained the paraffin block, he then undertook an initial examination whereby he applied what are described as the H&E, hematoxylin and eosin dye, which is the same one as had been applied to the ESR slide, a fairly standard dye. And Dr. Miller, under examination under the microscope, described the two slides from the stains from the appellant's shirt as containing, and quote, and this is set out at paragraph 100 of the written case, cellular material that was compressed and admixed with the shirt fibres as if it had been smeared or brushed onto the shirt. The appearance of the cellular material suggested that it might represent CNS tissue. No such material was present on any of the other slides. And indeed, Dr. Miller, in his evidence at trial, used the expression upon his inspection of the H&E stain slides as saying that it might be central nervous system tissue. And I can provide the reference to that. In fact, I've just read it. It might represent CNS tissue. So even he was not anywhere near sure that he was dealing with CNS tissue.
Yeah.
And he then proceeded to undertake the staining using IHC techniques that were then employed.
The passage you just read to us where it says it might have been, that's taken from the affidavit sworn
taken from the affidavit.
last year. Was he as cautious, as guarded as that in his evidence?
He was, my lord, and yes. I'll just find my note of that.
167 or thereabouts.
Yes, he stated page 984 of the case.
Paragraph number?
Sorry, this is the notes,
Oh, sorry.
notes of evidence, volume 3.
Volume 3. 984, did you say?
Yes, 984. At line 10. Yes, it was an observation that you could diagnose from your microscopic examination is the question. It looked to me to be tissue that had small blood vessels within it, and it certainly could have been tissue of neuro origin. But I would not have been able to know that for certain without the use of some additional techniques, particularly immunostains.
Yep.
I think that's the ESR slide, isn't it? If you look back previous page, at line 24.
That is correct. At page 999 of the case, about line 14.
So 999.
999. Line 14. Just
So
looking
we're
at the
now-
H and
yes.
Sorry.
Yes, we're now dealing with 33033, which is one of the samples.
Yes, ma'am.
Yes.
Just looking at this H&E slide, my first guess would be some type of nerve tissue. However, I wouldn't be able to say that with 100% certainty without performing some additional immunostains to make sure that this material possesses the protein markers and the molecular markers that we expect to find in tissue from that site. But this is clearly not skin tissue or other types of common tissue that might enter a shirt from a superficial wound. This is very deep tissue. And he notes it's the same type of stain that has been applied as was applied to the ESR.
Was there ever, I'm sorry, this is probably an entirely silly question, but was there ever any examination of the issue as to how, if it was CNS tissue, it could have got onto his shirt without other blood staining?
Sorry, without
Other blood staining the shirt, the blood from the victim. Was that ever an issue in the trial?
It was never an issue at trial, but of course Mr. Sutherland had identified indicators of blood within the stains.
Yes. But one would have thought that if sufficient force had been applied to dislodge CNS tissue upwards to the shirt, that one would have thought that there would be more extensive blood staining, unless the shirt was protected in some way. That wasn't ever explored?
It may well have been explored in the context of the issue relating to how the tissue got onto the shirt.
Mm-hmm. Well,
the contest being between at the scene or shortly thereafter on the Crown case. There were two possibilities: splatter,
yeah.
and as Detective Sergeant Grantham gave evidence when he was asked directly by Mr. Behrens, that it might have been when he was removing an overgarment.
Yes, that seems rather more likely, doesn't it? I mean, splatter, given the violence that was used here, would be all over the garment, and one assumes there was some other garment being worn, which was disposed of.
Well, don't let me distract you at the moment, because you've plenty
Yes, because wasn't there evidence that there was a great deal of blood on the walls, and that in one area it had been occluded, I think was the word used, by the assailant. So effectively, his body was screening the wall from the blood that was going everywhere else.
Yes.
Indeed, my lord.
Mm-hmm. But perhaps tomorrow morning you can give me the reference to that particular evidence, but don't take any more time on it now.
So just returning to the IHC staining techniques that were employed.
We're back at the at volume 5.
Well, perhaps the best place to go to is, in fact, the respondent's case.
Right. About paragraph 100.
Yes, my lord. So, paragraph 101, 4 stains were applied which were expected to be positive for CNS tissue, and 3 stains were applied which were expected to be negative for CNS tissue. And then 90 or more pieces of different types of tissue set out in a so-called multi-tissue control array was mounted on each slide and also tested with the same stains. And this is what Dr. Miller refers to as his controls. The slides with samples of the cellular material from the 2 stains reacted as CNS tissue would for all 7 stains on Dr. Miller's evidence. The control samples reacted as expected, and in his opinion, the results were conclusive of CNS tissue. Now, in preparation for this trial, Dr. Miller's evidence, or his professional opinion, has been peer-reviewed by Professor Gowan. Sorry, in preparation for the appeal.
The appeal?
The appeal, I'm sorry. His affidavit is in volume 5, at tab 20. Professor Gowan is a clinical professor of pathology at the University of British Columbia in Vancouver. He specialises in the diagnostic and research applications of IHC, and he's medical director and chief pathologist at Phenopath Laboratories in Seattle.
It's very impressive how one goes around the world in this thing. It's a very highly specialised technique, I imagine, with only a few people who know what they're doing. Is that
certainly
actually,
at the top tier?
Yes.
Are recognised and known throughout the world.
Yeah.
Unfortunately, Professor Gowan's very impressive resume was initially omitted from the affidavit, or at least wise the copy that ended up in the bundles, but his resume is at tab 4 of the second supplementary bundle, if that wishes to be noted.
Yes, with his CV and
So he carried out the same tasks or went through the same steps as Dr. Miller. Firstly, he visually inspected the H&E stained slides, and at paragraph 7, his results are set out there. Those sections demonstrate the presence of eosinophilic non-necrotic tissue with intact nuclei, all of which have a neural appearance. In respect of the IHC work, which of course is the most important, Professor Gowan noted that all markers reacted as expected for neural tissue. This is at paragraph 8. And furthermore, Professor Gowan noted that it was possible to discern a fibrillar pattern to the immunostaining, further confirming the neural nature of the tissue. At paragraph 9, Professor Gowan stated, "I have no issues whatsoever with Dr. Miller's methodology, and the slide preparations are of extremely high quality and easily interpreted. All the controls, both positive and negative, are excellent and more than adequate to permit definitive interpretation of the specimen in question." He concluded that without doubt Dr. Miller's studies conclusively demonstrate that the tissue fragments represent central nerve system tissue. He, of course, had the slides themselves, he viewed them, of course.
Is there any discussion about the problem of timing? Because you remember the point was being made that these samples lay unprotected for something like 59 days, as opposed to what might have been a period of some hours, and that would make a radical difference. So far, in what we've looked at this afternoon, there's not been any discussion of that, but is there any attention being paid to that anywhere?
Well, perhaps it is worthwhile just noting, Professor Gowan does touch on that.
Right.
More than touches on it.
This in the section dealing with mummies and so on.
That's right. Yes. Paragraph 15 he refers to Dr. Sheard's allegations that tissue dried for such a long period of time, as was the tissue on the shirt in this case, could not have demonstrated antigen retention. He makes reference to the scientific literature about ancient pieces of mummified tissue still being able to be subjected to IHC analysis. But the point is that the key is when was the tissue fixed. And Dr. Sheard's criticism applies whether the sample was examined 59 days later or a day later. The essential issue to be determined is whether or not the sample of tissue has been fixed. And a number of the experts...
So what do you mean by fixed in that context?
Stopping the degenerative process.
Oh, I see.
It becomes preserved. And it's fundamental and basic work of the pathologist that the surgeon preserves the sample that he takes from the body. And indeed, Dr. Miller and a number of the other expert witnesses make reference to air fixing. Professor Sinek made reference to it, whereby the surgeon waves the samples put on the slide and waves it in the air to fix it. Yes. And that's rapid air drying fixing.
Well, once it's fixed, it presumably is fixed for the duration, however long it takes to conduct experiments. I mean, this reference to Egyptian and Peruvian mummies, we don't know when the fixing process took place in these ancient techniques, no. But it may have been quite shortly after death, otherwise the corpses would deteriorate. I mean, I simply don't know what the answer to this. 59 days is a long period. And the argument is that it was so long that really you can't, you're not left with anything that can be subjected to any proper analysis. And I just wonder whether he's really faced up to that.
Well, in my submission, I suspect if he hasn't examined it, it's really a case of overlooking it because it is so fundamental.
Yeah.
I'm wondering what you're wanting us to make of this. We can see from this that Professor Gowan endorses Dr. Miller's work. We've also seen that Dr. Sheard and Professor Gatton are highly critical of it. And I wouldn't have thought we would be able, simply from reading the documents, to conclude ourselves as to which is a more reliable body of evidence. Or are you inviting us to reach a conclusion on the papers?
Well, I acknowledge that difficulty.
Yes. I mean, obviously, Professor Gowan's got a very impressive CV, but so has Professor Gatton.
I think these reports are characterised by the somewhat unrestrained fashion in which various experts express views about opinions that have been voiced by others. But I mean, if we were to remove that to one side, we've got to look at the actual core evidence here. And as my Lord, the Deputy President, points out, here a specific criticism has been made that the level of degeneration between the time that this material came onto the shirt and the time that it was subject to fixing, that there is an unquantifiable rate of degeneration taking place. And the central thesis, as I see it, of Professor Sherd on this aspect is that means that any analysis cannot be reliable. Now, as my Lord pointed out, it doesn't seem that Professor Gowan directly addressed that question in paragraph 15. Did he?
Well, that's all he does in terms of touching on it.
Yeah.
Is this what he's? Is this the point of referring to the intact nuclei and the non-necrotic and eosinophilic tissue?
Yes, indeed, my lady. The fact remains, the fundamental fact remains that none of these pathologists would have been able to have proffered an opinion if there was deteriorated or degraded cellular material such that you can't tell what it is.
Well, non-necrotic, I may be wrong, but it indicates to me that it hasn't deteriorated. I mean, if it was deteriorated, you would say it was necrotic and was therefore incapable of examination. So he rather suggests that there, but there may be a question of degree. Again, that the longer it lasts, is in the open air, the more difficult it is to be really confident what you're dealing with.
Dr. Temple Camp, in his affidavit, who was, of course, the witness who at trial gave direct evidence about the mechanism of rapid air drying or fixing.
Yes.
Went into it in some detail, and he also goes into some detail in his affidavit, and I will take the board to that presently in my submissions. But the short point of his evidence, as it was at trial, was that yes, there will be. Degeneration starts immediately. The material leaves the body and is cut off from a blood supply. And what is required is to stop that degeneration quickly. And as I alluded to previously, one way of doing that is applying substances like alcohol or other chemicals. And another one is very simple, which is this process of air drying, which fixes the material. Now, in the process of doing that, in the process of literally walking the sample from the theatre to the laboratory, there may well be deterioration in the sample, such that when the pathologist gets it, it won't be perfect. There will be
essentially, your point is that you can, whatever the rate of degradation or whatever the rate of deterioration, you can tell by the techniques employed that there was sufficient material remaining that would allow you to make a confident analysis.
Indeed.
And in a sense, what you say is all this talk about degradation is really irrelevant.
Indeed, my lord. And that is indeed the profession, that is the expertise of people like Dr. Miller, who in his affidavit says he gets referrals from all over the United States, the most difficult cases to interpret.
Yes, but just concentrating on the degeneration point, there's a mismatch, isn't there? Sheard and Gatter say it's been, this stuff, before it came to be analysed, had been lying around for 50-odd days. There was some evidence from Dr. Teo that there was an appearance of some degeneration. Therefore, the examination by the antibodies is worthless because you haven't got a similarly degenerated control sample to test your antibodies on. That's one half of the argument. Miller's evidence was there may or may not have been degeneration visible to the eye in some of the sample, but I could tell what I had got included bits that weren't degenerated at all. He said in evidence, from looking at it, it had to be very small, very fresh, smeared very fast, and I can tell from the degree of preservation of that cellular material, nuclei still intact, that the specimen dried very rapidly. Now, they're simply not talking the same language, these two. And the same is true of Garn, isn't it? He doesn't specifically address the question of what is wrong with, from his point of view, what is wrong with the Gatter-Sheard proposition that you have to have a degenerated control sample.
Well, he
I mean, he may do it inferentially, and that may be what you're asking us to accept.
Sorry, my lord. Paragraph 13 of Professor Gowan's affidavit, he talks about controls.
No two tissues examined in a routine pathology laboratory are fixed under identical conditions. Yes, I see.
That doesn't really directly address the question whether a control is required in order to produce reliable results. I mean, Sheard was quite emphatic about that, wasn't he? That in order to get reliable results here, you need to have a controlled sample. And because of the elapse of 59 days, it was impossible to replicate the same level of degradation. Therefore, you couldn't have a controlled sample. Therefore, you couldn't come up with a reliable answer. Professor Gard doesn't seem to address that directly, does he?
I mean, that's the argument. Paragraph 11, if one starts at paragraph 11.
Well, that's just vulgar abuse, isn't it?
Well,
but you're right, that inferentially he is saying, I think, there may or may not have been some degeneration of some parts of the sample, but the bits that were examined weren't. Otherwise, we wouldn't be able to see what we can see.
Yeah.
that's correct, my lord.
Well, do you go further and say that inferentially he's saying that you don't need a controlled sample here at all?
Well, it depends what we talk about by control.
Yeah, well,
definition.
Dr.
Sheard's...
Dr. Sheard, he says you need a control which is in the same condition as the sample that you're trying to identify.
Well, in my respectful submission, if that is the case, then so many samples taken from crime scenes, subjected to DNA analysis, all manner of articles which are the subject of forensic processes on Dr. Sheard's analysis would require a control.
They're not talking about DNA analysis. They're talking about IHC analysis. That's the area of dispute between them. And what Miller seems to be saying is that this sample is good enough for me to recognise. It's not so badly degenerated that it can't be used for recognition. What the others are saying, I think there is some other evidence disputing that, saying that it's too degenerate in any event. But what the scientists we've been talking about say is that you can't do it without a control group. You can't make that positive identification. And they really are saying that it isn't suitable for forensic analysis or use.
The serious distinction that appears to be drawn between forensic analysis and diagnostic analysis, because Professor Gowan and Dr. Miller, it's their bread and butter. They don't have a control. Yeah. They receive it as best it is received from the surgeon or from wherever, and it will have deterioration in it. They don't have a control to compare the IHC analysis to the actual sample that they're providing a diagnosis of.
But they know they're dealing with a sample of, for example, brain tissue that's been taken from a person. Whereas it's common ground, as I understand it, that to use this technique for forensic purposes was novel, and hence the article which Dr. Miller and others published explaining the success, as they saw it, in using the technique for this purpose. And the argument made against them is that, well, unless you know how 59 days old brain behaves when you subject it to these tests, it's difficult to know if the results that you are getting when you subject an unknown material to the tests indicate that it is in fact brain material.
That is what they put forward. But in my submission, both Dr. Miller and Professor Gowan are saying that situation is no different from the normal situation in which I apply IHC.
Well, it's worth noticing that Professor Sherd, whose affidavit is in volume 6, tab 26, saw what Professor Gowan was saying, and he has his own commentary. He replies to it at MS 2366 to 2367. This is tab 26. And he's saying, well, he makes various criticisms. Dr. Gowan is too superficial. He doesn't doubt that ancient techniques of various things can be localized, but it doesn't assist in this particular case, and you have to understand precisely what is being done here, and Professor Gowan hasn't really addressed himself to us. So we have a very sharp conflict between views by highly experienced people on various continents in the world, which is something we can't resolve, really, can we? Sensibly, I mean, we need really, somebody's going to have to try to resolve this, if it's necessary. I mean, you may be able to persuade us that, interesting though this dispute is, it isn't actually crucial to your case, because there are other factors, and many other factors, which would override it anyway. I don't know whether you're going that far, but that's a possible line.
Well, the respondent's case has set out to argue that on the material available to the board, there is nothing in the appellant's material which should give the board concern that the conviction is unsafe.
Yeah.
If we're left unconvinced by that, isn't there, on one view, a respectable argument between well-qualified experts? Isn't that something that the trier of fact should have had the opportunity to consider? It's a matter of fact whether this was brain tissue, and it was critical fact in this case.
Well, this perhaps takes me back to what I was invited to do if there was an appropriate point, which takes me back to the appeal process and, may I say, the responsibility of the appeal court to determine the issue for itself.
But if it is a true dispute between respectable scientists, isn't that an issue for trial?
Well, in my submission, we don't reach that point until we have tested this evidence. until it has been subject to cross-examination, but instead of having two arguments...
To what end?
To the end, to see whether or not the evidence is cogent, such that the appeal court cannot be satisfied that the conviction is safe.
But surely cogency is a matter of legal cogency in this context.
Well,
once it's a respectable dispute between experts.
Well, in my submission, ma'am, an appeal court cannot get to that point until it has examined the evidence that is being put forward on the paper, because it is the responsibility of the appeal court to get to that point, to make findings as to the probative value of the evidence that is being put before it. May I take the board perhaps to the respondent's case at paragraph 72.
Sorry, which one? Your case?
My case, my lord.
62.
72, paragraph 72.
Yes.
And in that paragraph, I refer to the case of Jones. And it's the case that I've already referred the board to. And there, the English Court of Appeal received the new evidence on the basis that, if accepted, it would afford a ground to allow the appeal. The Crown called rebuttal evidence, and following a careful assessment of the new evidence, including cross-examination, the court preferred that of the Crown. If the new expert evidence stood alone, the conviction could not be regarded as unsafe, and even if it had raised doubt in the court's mind, such doubt would have been, quote, dispelled by the cumulative effect of the other evidence in the case. It dismissed the appeal. And similarly, in the case of Hall, which can be found at tab 5 of the...
Sorry, that's really a reference, though, to legal cogency, isn't it? Rather than... I'm just trying to understand, you seem to be inviting us to decide as between the scientific evidence. But if in this case, arguably, unlike in Jones, if the evidence is preferred by the jury, it must be cogent in terms of the safeness of the verdict.
But in my submission, my lady, it's not a question for the jury, it's a question for the appeal court.
Well, I understand that in terms of the impact on the trial and to what extent this new evidence would be cogent in that connection. I'm not sure about whether that means it's for the appeal court to determine which evidence is to be accepted.
Yes. I mean, one way of looking at it is to say that the task of the appeal court is to decide whether a verdict reached in the absence of the evidence in question constitutes a miscarriage of justice, rather than deciding whether the evidence, if heard, would actually be accepted or not.
But one has to start, my lord, with the position that the verdict is a proper one. There was a fair trial, and only can the jury's verdict be disturbed on appeal if an appeal court is satisfied that it is in the interests of justice that evidence which is put forward as fresh evidence, or purportedly as fresh evidence on appeal, is so cogent that the one trial principle, that there has been a fair trial, and notwithstanding there's been a fair trial, there must be another trial.
Well, perhaps I'm just repeating what others have said, but one assumes, first of all, your point that as far as it went, given the evidence that was led then, the trial was fair. There hasn't been a criticism of that, leaving aside the tiny point on identification. But then we get presented with competing scientific evidence. And it could be said that both packages, both on the one side and the other, are cogent in the sense that on paper they're equally convincing. And what one then has to decide, well, which prevails? And that is the Chief Justice's point, that that's for the trier of fact to resolve, and we haven't yet got to that point. Somebody's going to have to resolve it by looking at the evidence and having it tested.
Someone will need to resolve it. I agree, my lord, but in my submission, it is for the appeal court to resolve it.
In New Zealand?
In New Zealand. If that is where the board gets to, yeah. I'm attempting to make an argument that you don't need to do that.
Well, there are two ways of reaching that point. One would be, well, one side's version is not really convincing. I mean, it's got sufficient flaws in it, patent on the paper, and it can then be regarded as not worth taking the trouble to examine because it's not going to get anyone anywhere. The other would be, well, even assuming that the other side prevails after examination, there are other factors in the case which would point to the safety of the conviction in any event. And that's something we're going to have to address, and time is moving on, and I wonder whether we should just proceed from here. We've seen the various bits of brain tissue evidence, and I don't know there's very much more we need to get on that, but I may be wrong. Maybe there's more you want to address us to from your written case before we proceed to the second ground of appeal.
May I just, with your lordship's, my lady's indulgence, just refer to paragraph 73 of the written case.
Yes.
And the quote, the passage that is cited in Hall, which I was going to take the board to, which is the statement of Lord Justice Judge in Hakela, which talks about the very thing that the exchange we've just had. And it talks about fresh evidence that is disputed, and that it is for this court, the appeal court, to decide to what extent it should be accepted or rejected. And unless this evaluation is carried out, it's difficult to see how this court can carry out its statutory responsibility in a fresh evidence case and exercise its powers of review to guard against the possibility of injustice.
I think that must be read in the light of an earlier statement by Lord Bingham in the case of Graham, in which he said, as an alternative, if the court is left in any doubt about the safety of the conviction, then it should quash the conviction and, if necessary, order a retrial.
Well, you do both, don't you?
That's right. You do.
Because the fresh evidence is ex hypothesi raised on appeal and wasn't raised at the trial, it has to be the responsibility of the appeal court to evaluate it. You evaluate it either on paper or, if necessary, after hearing it given. And once you evaluate it, you then address yourself to the question of whether it leaves you in doubt about the safety of the conviction or not. And you don't necessarily have entirely to reject it, to be left in a state of mind in which the conviction is perfectly safe. You might, or you might not. Equally, you might not necessarily accept it, but still think, at least you might not be sure it's right, but nevertheless accept that it raises a sufficient query for it to be impossible to be sure of the safety of the conviction. You simply have to go through it step by step.
Indeed, my lord.
Can you just help me about one thing about the brain, the detail of the brain evidence? I've got the point about I've got the, as it were, the different approaches of Professor Gowan and Professor Sheard, is there any evidence anywhere of this technique having been used in a forensic context, apart from this case? I mean, none the worse for it necessarily, but is there any?
Our best endeavours were to locate a passage in the expert evidence text of Freckleton.
Oh, yes.
Which...
From Victoria.
Yes.
Yeah.
This is at paragraph 81.1870 of the text, which states that, second paragraph, I quote, "Although well established in the medical and research areas, immunohistochemistry has been used sparingly in forensic matters." And then cites, and that's it. It then cites a researcher, but that's pithy. But that's all it says.
That's all we know.
Sparingly, Mr. Lawrence, for once. Namely, this case, we just don't know.
No, we don't. Thank you very much.
It's interesting though, isn't it? Because this case is now quite old.
It is, yes.
Well, where would you like to go next?
Your Lordship, I think, is pushing me on to the second ground.
It's a fascinating subject. We can talk about it forever, but I think we should move on if we can.
And this is the allegation of expert shopping.
Yes, all
Yes.
right. Yes.
The recent discovery of Dr. Teo's views in my submission does not change how Detective Inspector Grantham's approach to his investigatory task should be characterised. And his task was to find an international expert who could advance the identification issue and undertake the more advanced analysis required to definitively determine whether the samples from the appellant's shirt was central nervous system tissue. Now, both in his disclosed notebook and in evidence at trial, Detective Sergeant Grantham records and set out how events unfolded. A history is provided that led him to Dr. Miller, and this is further outlined in Detective Inspector Grantham's affidavit. The respondent makes 3 submissions in response to the appellant's allegations. Firstly, on the totality of the material, it is clear in my submission what Detective Sergeant Grantham was attempting to do in exhausting the line of inquiry relating to the identification of the tissue located on the shirt, and that was to obtain a definitive answer, one way or the other. Secondly, while acknowledging that Dr. Teo's views ought to have been the subject of disclosure, there was in fact no suppression from the defence of the details of who Detective Sergeant Grantham had sought reference to in order to advance the inquiry in this area. And indeed it was recorded in the notebook he kept of his interactions, which was disclosed.
I'm not sure I've quite fully understood what you're saying. Is it helpful to look again at that document in tab 18 of the supplementary volume? This is the memorandum which was not disclosed, which we saw at the beginning of yesterday. Is this a background to this chapter?
Perhaps the most useful document is one that was made available to the board this morning,
Right.
which is a copy of the relevant passages, and I apologise for it coming in so late.
Yes.
A copy of Detective Grantham's notebook.
Right, so that's what it is, the manuscript document.
Yes.
And this was disclosed? Yes.
It was, ma'am, yes. It was disclosed on the 26th of April 2001.
2001.
And perhaps if I can, with the board's leave, take you through the salient parts, and I'll go as quickly as I can. On the 11th of December 2000, and that's at page 51, if your lordships, my lady, just look in the top right-hand corner of the document. It's the third page in.
Third page? Yes.
An entry for the 11th of the 12th, 2000, and there's a reference there to a John Manning. FBI do not have a specialist pathologist. FBI suggested Armed Forces Institute pathologist Dr. William Rodriguez, and then there's a phone number. Call made to Rodriguez, but not able to be spoken to. On the 13th of December, which is over the page, on the back of the page, a further attempt to contact Dr. Rodriguez. Later in the morning, there is a call made to a Dr. Martin Sage, who perhaps with the leave of the court I can advise is a well-known forensic pathologist in New Zealand, who advises of specific stains for neurofilaments, stain positive for that, and then makes a comment relating to possible outcomes. On the 14th of December, a further call made to Dr. Rodriguez, and if one turns over the page at 08:47 hours, Dr. Rodriguez comes back to him, explains the situation. He appears confident that they could help. Then further down the page at 11:50 hours, received a call from Detective Inspector Brew. He was excited about the American assistance, unsure whether anybody but myself or Dr. Thompson should transport the items to the US as of the evidential value. Later presentations in court and having to brief doctors in the USA. Detective Inspector Brew then requires a letter from Ken Thompson. He's the earlier pathologist, explaining his reluctance to proceed with the matter and his suggestion that they contact the FBI. Now, the letter which was produced is the letter that is part of the bundle and is attached to Mr. Jessop's affidavit at page 2605 of the bundle. Which is tab 34.
In volume 5?
Sorry, in volume 7.
Volume 6, thank you.
Right, it's page 2650.
Must be volume 7.
2650, volume 7.
Yes.
And Dr. Thompson, we note the date, the 14th of December, summarises where he gets to with the slide. This is, of course, the ESR slide. The slide has scanty material present, and while there are some cells which are possibly of nervous system origin, it's impossible to confirm this without specific tests which cannot be performed on a previously stained slide. There are several histochemical tests which can be undertaken to identify particular types of tissue, e.g. nervous tissue, and the letter goes on. I won't go completely through it, but there's a reference there to perhaps contacting a major forensic institution such as the FBI or the Armed Forces Institute of Pathology.
And this, I can't remember, was this disclosed, or it wasn't disclosed, but it's sufficiently referred to, you say, in the notebook? What's...
I cannot give you a definitive answer.
That's right.
It is attached to Mr. Jessop's affidavit, which was sworn.
So suggesting it's new to the defence?
No, it appears that it was part of. The answer is there.
Oh, it does actually. Well, I wonder. I'm looking at page 2605,
Yes.
which rather suggests it was disclosed. 2605.
I'm sorry, my lord, I'm not sure. My learned friend has pointed out a fax detail at the top of the exhibit. 5 December 08. Sorry, 5 December.
Well, I see. So maybe this is obtained after the trial.
Which may be that it was sourced directly from
Yes.
Dr. Thompson in December in 2008.
Right. Mm-hmm.
On the 20th of December, and that is the next page over, the dates become somewhat difficult to determine because of the photocopying, but the 20th of December, Wednesday, Detective Sergeant Grantham records that he receives a call from Dr. Rodriguez. They will accept the case. Dr. Rodriguez will contact me 3 or 4 January to set dates and times. In the new year, on the 5th of January, which is the next page over, Friday the 5th of January, there is this meeting which is referred to in the evidence with the local pathologists, Pang and Temple Camp, who mentioned for the first time the name Rod Miller, Texas. They photographed the cells. Beth Sinnock, the Auckland neuropathologist, is also mentioned. And then there are further references to what happened to the ESR slide, it being viewed and photographed, and then retrieved over the page later in the afternoon by Detective Sergeant Grantham. Then on Monday, Dr. Pang is seen again, as is Temple Camp. There's a reference then to Dr. Teo. His full name is set out there. His phone number at Wellington Hospital.
Sorry, what page are you on?
That is it's the entry for the 8th of January.
I see. Yes, thank you.
And then on the 9th of January, the notebook records slide from safe, slide to Dr. Teo, slide back from Dr. Teo. Now, as with Pang and Temple Camp, the conferences with them, there is no actual notation of the content of the interaction with the doctors.
So what we have in the document we saw yesterday is a statement that he was concerned about Dr. Teo's comment when he saw the slide that he didn't think that the appellant should be convicted of murder on the strength of the cells in the slide. That doesn't appear in the manuscript document, does it?
That does not appear in the manuscript document. But I would just make the observation for the benefit of the detective sergeant that equally he hasn't recorded the positive
It's a
response
pretty neutral.
that he got.
It's just a fairly uninformative, neutral statement.
guess that diary
except it shows
presents,
who he's talking to.
Yeah.
But it certainly is a record of who he's talking to, and indeed,
I think you can make the point that certainly if he was trying to suppress anything, he wouldn't have referred to Dr. Teal,
No.
because it might well have prompted a diligent defence lawyer to try to find something else out about him, knowing that that he wasn't going to give evidence for the prosecution.
just continuing on very quickly, the 17th of January, which is over the page, in fact it comes out as 7/1/2001 towards the bottom of the page. There's a reference there to Dr. Rodriguez and Dr. Rodriguez's email address. On the 17th, later that day, at the top of the next page, we see the slide to Dr. Lockett. Now we know that on the 18th of January is the date of the email of Dr. Rodriguez advising they'll no longer take the case. And that's at the bundle at page 2741. Dr. Lockett is the person, the pathologist, who contacts Dr. Miller in the United States, and in the appellant's supplementary bundle, volume 19, volume 19, tab 19, starting at page 326. We see that this is Dr. Bruce Lockhart's inquiry of Dr. Miller. Dr. Miller's response at page 325, and a further exchange at page 324.
Yes.
Returning to the notebook on the 25th of January, which, if my lords, my lady, if you turn the page, it's Thursday is the most easily seen reference.
Yeah.
It's
Reference
the
to
25th.
Dr. Miller.
It's apparent for the first time, Detective Sergeant Grantham speaks with Dr. Rod Miller, notes, discuss possibilities of removing smear from slide and staining a section of the slide smear. Confident 95% smear can be lifted. Results will speak for themselves. And of course that's in the context of this exercise of actually lifting it from the ESR slide, which was the initial proposal. In the notebook, Dr. Grantham subsequently goes to the United States 4th of February through to the 12th of February. Then on the 1st of March,
Just keeping in the context, I've got 324 open in the supplemental bundle, which is the exchange of emails that you took us to. And you can see that from the top half of 324 that Dr. Miller's initial response was to raise the question of the age of the sample.
Yes.
So he's clearly alive to it. Doesn't answer the question, but he's clearly alive. May not make any difference if it's that old. We'll have to see, effectively.
Yes.
Yes, I see.
So the next reference is the 1st of March, which the easiest way of doing it is that's the penultimate page, Thursday. Sorry, the second to last leaf in the bundle. Looks like the second of the third, in fact, at the bottom, but the previous day is the first, and at the end of the day, 23:17, Detective Sergeant Grantham takes a call from Dr. David Doyle, Detective Neuropathology, Glasgow. Now, it needs to be remembered that way back on the 23rd of January, Dr. Doyle had been sent a letter by Detective Inspector Grantham asking if he could assist, and that's at page 2752 of the bundle, which is volume 7, 2752. Tab 44. And there's a reasonably lengthy letter from Detective Sergeant Grantham outlining the situation and inquiring if Dr. Doyle can be of any assistance. And then returning to the notebook, the next day, after receiving the call late at night from Dr. David Doyle, the officer at 7:45 on the 2nd of March records, prepare letter, fax for Dr. Doyle, send information by email. And just to complete the notebook, on the very last page, the back page, on the 23rd of April, Dr. Doyle's email address is recorded in the notebook. And just following on with the Dr. Doyle interaction, after the letter of the 23rd of January, page 2752, we have the phone call, almost out of the blue, on the 1st of March, as recorded.
Which page are we at for that?
That's volume 7,
Yes.
tab 44, 2752.
So this is Detective Sergeant Grantham
That's
communicating
right,
with
that's
Dr.
his letter
Doyle.
of the 23rd. The 1st of March is the next is the next contact when Dr. Doyle
Yes.
phones, and the officer says, records also that he prepares a letter to send. And then if one goes to page 2743, tab 44, we can see that letter. as discussed on the telephone last evening. Please find enclosed. And then one has to go back to the to page 2748, a fax of the 12th of April 2001. I guess it could almost be a hurry-up communication. And then we have Dr. Doyle's letter of the 12th of April at page 2750, which has already been traversed. One thing of note, which is in my submission worth noting, is that Dr. Doyle is surprised about the amount of material that there is available to work on, and that what he thought might be required in terms of multiplying the amount of tissue, or amplification I should say, won't actually be required. It refers to the techniques of immunocytochemistry applied in the United States as being similar to those we use routinely in this clinical pathology, accredited neuropathology laboratory. He says, I have no difficulties accepting the interpretation made in the USA. He then goes on to talk about what he would like to see done in terms of control material with other human brain in similar amounts.
He's not indicating that he's saying that the methodology used was correct, is he? But he makes a distinction between the interpretation, and in respect of the methodology, he says that he refers to adequacy of control material. So he's not purporting to approve what's happened, has he? Is he?
Well, in terms of description, overall description or assessment of what he's saying, in my submission, he sees nothing wrong with what has happened. It's more a case of, I suspect, if I can use the term belts and braces, this is, you're vulnerable perhaps here and here.
Is at the bottom of page 2750, the further work he might have done?
Yes.
He's been told specifically, hasn't he, in the letter from Mr. Grantham, that the slide was taken 58 days after the murders?
Yes.
Yes, 2753. Yeah.
Yeah.
Then the next in the chronology, page 2747, the facts of the 19th of April, where he refers to the controls of Dr. Miller, which would not be immediately apparent to Dr. Doyle, the 80 small sections of normal and tumour tissue, the multi-tumour sandwich blocks, which are on each of the slides as being the controls. And then the reply on the 19th, the same day, by Dr. Doyle, handwritten, page 2746. Thank you for your informative note. I look forward to hearing the further
Decisions.
Decisions. Thank you.
Well, maybe not.
I think it is, yes.
And then the facts.
Yes.
Then clearly there's a decision made not to utilise Dr. Doyle's services, and his facts of, it says 27 February.
Which page are we looking at now?
It's at page 2744.
Yes.
I must say I'm limited by the formal record. It's dated 27 February, if indeed that is the correct date.
Well, it's answering one of the 19th, looks, so it probably is.
Yes.
Thank you for your facts of the 19th of February.
Why do you have reservations about that?
Just in terms of the chronology, it seems to fit.
It does look a bit odd.
It seems as if it should be the 27th of April.
It's out of place, isn't it?
And thank you for your facts of 19 February when the fax was 19 April.
Yes.
And it seems likely that I'm disappointed not to have had the opportunity to assist you. Although, as my learned friend notes, if you look at the fax header, it says 27 February, so I apologise for how opaque that is. But in any event, the point of taking your lordships, my lady, through all that was that in my submission, firstly, all these details were disclosed, and all the experts who were contacted were named, and an outline provided of the way in which matters unfolded. As far as Detective Sergeant Grantham was concerned, no secret was made either to the defence nor at trial of the very extensive inquiries that had to be undertaken to obtain the expert, and in particular the expert IHC analysis that was ultimately called at trial. In my submission, it was very clear that the work required to be undertaken overseas required specialist expertise, and that was the very reason the New Zealand Police had to go all the way to Dr. Miller. And as was acknowledged yesterday, as I understand it, the defence were under no illusions. The exercise was something new and novel, out of the ordinary. And Dr. Sinek's communication to Mr. Behrens was to that effect. We know, of course, that the appellant obtained expert advice from the neuropathologist Dr. Sinek, and of course overseas from Dr. Venesis. Now, turning to the...
Well, I wonder, since it is pretty well on 4 o'clock, that clock being 5 minutes slow, whether this is a point at which to break. How are we doing for time? Bearing in mind we have to finish tomorrow.
I will certainly endeavour to make my best efforts to conclude in order for my learned friend to have an opportunity in reply.
Yes. Well, I think if you should aim to try to finish by lunchtime, is that pushing it too much? See what you can do. We'll have to rise at 4 o'clock. I mean, that's our standard practice, so
Yes.
You'll have to allow for enough time for a reply before 4 o'clock.
If that is the time, then I will
That is
finish
the
at
timing.
12 o'clock.
Good. Well, we look forward to seeing you all tomorrow morning at 10:30.